All right, we're on the record. This is people of the state of Michigan versus Parnell Michael McCreary, 2356485. Mr. McCreary is charged with count 1 assault, attempted murder, count 2 assault, to do great bodily harm less than murder or by strangulation. Count 3 weapons, firearms, possession by felon. Count 4 weapons, ammunition, possession by felon. Count 5 assault with dangerous weapons, malicious assault. Count 6, 7, 8, 9, 10 weapons, starting firearm with habitual offender fourth offense set for a hearing today. Appearances.
Edwin Milwaukee, P54828, appearing on behalf of the people.
And Laura Nersessian on behalf of the people, P67104.
Parnell Michael McCreary Gill on lowercase, natural person, not a person. If I may ask this court a question, address the court.
And good afternoon, Your Honor. Earl Washington, Neighborhood Defender Service, P31383, as the standby attorney.
What's your question?
First, I would like to object, no disrespect to SY here, but he does not represent me.
I know that.
Okay. Yes, but the prosecution.
Your objection has been noted on the record.
And the
You have a
prosecution and them are.
You have a question?
Yes.
What's the question?
I didn't know that the court would allow the prosecution to commit felonies in violation of state and federal
That's
law.
not a question, that's a statement. Okay, so we have a.
Also, the question
You're not
is.
gonna talk over me then.
All right.
So we have Attorney Washington as standby counsel. He does not represent you, but in the event that you need help, he's there to help you. This is your request that we're all here today, so you can begin with your request to the court.
I don't, he's not representing me.
We've already established
Yes.
that. So you can begin.
Yes.
I have your documentation here, so you can start.
I haven't had anything from the prosecutor's office. You gave the prosecution 2 orders to give me discovery under People versus Davey. The 225 Michigan Appeals 592, violation of a discovery order is grounds for dismissal. Also, I would like that the court, as well as the people, provide their bond numbers, their licenses to practice law. Yes, and their oath of office. Because right now at this point, I'm being violated. I would like to also have Kim Worthy here, the chief prosecutor, because she has committed crimes past and present. I would like a change of venue because DPD has been continuously retaliating over the years. It's well documented. People have been lying, making false complaints. They're using known perjurers. I've made reports with Detroit police, and I'm not being given the same rights as any other citizen. If a person is being called in and they're saying, well, hey, Mr. McCreary did this and did that, they come to my house, they bang on my door, they're impeding upon my freedoms, my sovereignty. They're a corporation. Corporations cannot act upon natural persons. Now, the case of Coins versus Virginia, 19 U.S. page 264, says that it started in D.C. They incorporated the inhabitants of D.C. and the states, other states. I am not a corporation. As I stated numerously in the beginning of this case, ab initio, I reserve my rights not to be compelled to perform under any contract or commercial agreement. I am a Moor's national sovereign. This court, as well as the people, have violated the Moroccan-American Treaty of Peace and Friendship of 28 June of 1786. Now, this quasi-contract that I presented to the courts, per the Michigan Supreme Court, the U.S. Supreme Court, this matter has already been litigated. And this court, as well as the people, are in default. And again, they refuse to give me their bond numbers, their names, and things of that nature so that I may properly file a lien in the federal court, as well as I'm preparing a 42 USC 1983 case. Again, the state has no duty to protect private citizens from private citizens under the Cheney versus Winnebago Department of Social Services 489 US 189 1989. If you go all the way back to the civil rights cases, the 13th and the 14th Amendments were created to protect African Americans from discrimination by city, county, and state and federal governments. And it also says in this case as well that they have no duty to protect private citizens from private citizens. So to compel performance of these corporate statutes, which it speaks about in Coins versus Virginia, again, 19 U.S. page 264, they created statutes to corporately punish the inhabitants of the city of Washington and the District of Columbia, and it went down into the other federal territories as well as the cities, counties, and the state governments. And they're committing fraud against the people. These these statutes that they have me charged with are unconstitutional, and I ask even though you're in default, I'm giving the state another chance, but this right here is already locked in. They're in default because the law says where they have a legal or moral duty to respond, their silence is their acquiescence, their tacit agreement. So they're in default, Your Honor. And I would ask that the court subpoena Kim Worthy here so that we may put her on the stand to answer for her subordinates' criminal behavior as well as her criminal behavior. Have documents here where it's clear that they, can I sit down for a minute? My back is kind of bothering me. That's what my legs are shaking. But I would like Kim Worthy to be brought in so that she can be questioned about the change of venue, the allegations, which are factual. But they sent me to prison for 15 years and 8 months for no crime at all. Judge Kirsten Frank Kelly was in Wayne County. She issued an order against me that was null and void. I was railroaded, sent to prison, did 15 years and 8 months where I lost my mother, family time away from my daughter who's now 24 years old. She's a mother. I'm a grandfather. I've been productive in the community since I've been home. They're trying to make me look like I'm a demon. But the paperwork shows the opposite. And I would like all of these things. I would like an evidentiary hearing so that we may put these documents into evidence and that this case can be properly litigated, because the prosecution is committing crime. So I ask that this court use this subpoena power and adhere to their oath of Article 6, Section 2 of the U.S. Constitution, as well as Michigan Code of Judicial Conduct, Canon 2B. And the paperwork is clear. They refuse to respond. Everything that is happening now is criminal. In violation is conspiracy, 18 U.S.C. 241. And in violations, Michigan misconduct in office, MCL 750.505. I have been humble with this court. I haven't been here just trying not to disrupt the court. I'm under threat, duress, and coercion. You know what I'm saying? They have constantly been retaliating against the Detroit police as the sheriffs, as well as Kim Worthy's office. And it's well documented. They sent me to prison off the testimony of a perjured witness. And I would like all these things to be adjudicated properly in this matter. And jurisdiction has been challenged per federal and state case law. The people have to prove jurisdiction. They have statements. The corpus delicti rule bars statements as hearsay out of court. And this is what they're going is they cannot make an affidavit for anyone. You see what I'm saying? My brother, as they claim, made these statements. I still haven't been given any discovery or anything. And they're in violation of the Michigan court case law, Court of Appeals case law, and People versus Davey. This court clearly twice told them to give them discovery, 225 Michigan Appeal 502. And they're still violating the court's orders. And this court, honorable court, should exercise the contempt powers and have these officers supposedly acting for the court, which are being criminal, to be put in jail until they comply and or fine. Detroit police has a history. They were prosecuted by the Department of Justice in 2001. Then they were under the consent decree into 2013. And they're still committing atrocious criminal behavior and acts against natural persons, natural citizens. You know, Judge, you're familiar with this case law. You're a licensed attorney and an elected or appointed judge. I don't know. But the Supreme Court under Marbury versus Madison rulings, they're decisive, let the decision stand. This court is bound to adhere to Supreme Court rulings. These statutes in which they're charging me with are unconstitutional in violation of the civil rights cases, as well as Cohen versus Virginia, the Supreme Court. And today, again, I respectfully compel this court to adhere to these things. And the Supreme Court says where a court does not have jurisdiction to act, or where they don't have jurisdiction and refuse to act, it's considered treason against the U.S. Constitution, Your Honor. And the paperwork is clear. All parties that I've served these papers on are in default, Your Honor. And I ask that this court, like on page 13 and 14, I clearly stated in the offer, I'm the offerer, they're the offerees, And this process is approved by the Michigan Court of Appeals, Michigan Supreme Court, in which they cite federal court cases on the federal court cases, cite these cases as well. Give me a second, please. On page 13, it says, offerees 1 and 2 agree that all above and below statements are true, and they have until May 24, 2023 to admit or deny the above, and agree that terms, A, failure to hold state laws unconstitutional, and void ab initio, agrees to give me in the sum of $5,000 in gold and silver coins and or Federal Reserve notes and assets in their personal and official capacity. B, failure to dismiss charges with prejudice and grant all of the above, all of the supra and infra, agreed to give me $500,000 and agreed to be charged via MCL 750, 505, 18 USC 241, 18 USC 242 by the U.S. Attorney and the state's attorney for their crimes via Turner Associates Inc. versus Small Parks Inc. 59 Federal Subsection 674 at page 680 through 82. Eastern District of Michigan, 1999, where they have a legal and moral duty to speak and agree that if they, offerees 1 and 2, try to impair this quality contract, argue or try to litigate this case further, instead of dismissal with prejudice, agree to give me $1 million in their individual capacity via Holland versus Thoroughbreds Publishing Code 46, Federal Subsection 681 at 685 through 687, Eastern District of Michigan. Then there's affidavit of truth. I, Carnell M. McQuarrie Eel, says that the above is true and correct, and email these pleadings to offerees 1 and 2, which is Kim Worthy, as well as this court on May 10th of 2023, and I signed it. The law is clear, Judge, and this court must enforce the laws written by the higher courts. This court is an administrative district court acting on a corporate level, and they cannot conflict, basically issue their rulings in conflict with federal Supreme Court ruling, which they have taken an oath to do so. If this honorable court refused to do so, it would be treason against the U.S. Constitution. And I ask that this case be dismissed at this juncture because statements, I have not been given anything by the prosecution and the people. And I would also ask that this court exercises subpoena power and have Kim Worthy come here. She's not God. She's not a queen. She's not an empress or anything. She's an elected official. And her history precedes herself as committing crimes against citizens like Devontae Sanford, Daryl Siggers, all these people that they're saying that they're trying to help get out of prison under the wrongful convictions unit. Valerie R. Newman was my former attorney, and that also makes it a conflict of interest because Judge Kirsten Frank Kelly heard her on appeal. She let the judge do it, and I had to do almost 16 years in prison for a crime where there was no legal jurisdiction at all. And there's documented evidence, paperwork, court seal, signature, and I'm being criminally retaliated against by the people. There's no way they can wiggle their way out of this. And I would like these things to be adjudicated and evidence. I would like an evidentiary hearing so we can admit evidence and or suppress evidence. I haven't been given discovery. I didn't even know I had court the first time I came. I had to go online and look it up. These are the games that they're playing. And I would like their oaths of office, their bonds, as well as other things. Because they're committing felonies, Your Honor. All due respect, and like I said, I don't have anything personal against this court or anything. I just request that this court adhere to the supremacy clause of the U.S. Constitution and hold that these state statutes in which they have me charged with are constitutional based on the U.S. Supreme Court. And what is the case? The Cheney versus Winnebago Department of Social Services. There was a young child whom the mother relays that the father was beating the child, and the child died. The mother sued all the way to the U.S. Supreme Court. And the U.S. Supreme Court held that no matter how bad or gruesome that this case was, when it concerned the case, that the states have no duty to protect citizens from other citizens. Anything that compels performance, there has to be a contract. And again, I reserve my rights under UCC 1-308 and the common law UCC 1-103.6. And it's clear, Your Honor. And I ask that this court, do their sworn, fulfill their sworn oath under the Michigan rules, the Michigan Judicial Code of Conduct, The court is not to be swayed by public opinion or what the people may think or whatever it may be. Like the great honorable Judge Dalton A. Robes. When he was in office many years ago, he did the right thing. They tried to get him to send these young juveniles to prison. He said, no, these young men can be rehabilitated. And he sent them to juvenile prison. At this time, the prosecutor then went and attacked this judge. You see what I'm saying? You have a right and a duty to fulfill your constitutional oath, Your Honor, regardless of what they think about you or whatever else. These these statutes in which they're charging me with are unconstitutional. I never signed any agreements with the cities, counties, states, or whatever else to be governed by them, to adhere to their statutorily corporate statutes, which in Coins versus Virginia clearly states this is what the system is about. To create penitentiaries, to create prisons, hospitals, graveyards, streetlights, so on and so forth, in which today we live in this society. This society is clearly the matrix. The legal system is unconstitutional. These are corporate enterprises. They're no different than any other corporate enterprise when they provide services for the citizens. The case law clearly breaks it all down. I've never surrendered my sovereignty. Dred Scott versus Sanford clearly stated that blacks could not be citizens, were never intended to be citizens, and we were 3/4 of human beings. But under the democracy, pardon? 3/5. Okay, 3/5. Under the democracy, which is nothing but the mob rule of the old South and European inhabitants of this country, if someone killed someone, stole something, they were all the mob who go out there and hang them and do whatever else. So every government is entitled to a Republican form of government. Not a corporate. I'm not a corporation, right? I'm a natural person. The case law clearly breaks everything down, which everyone is in default. So I just ask that this court dismiss this case at this juncture. If the court does not, I demand under the supremacy clause, the subpoena power of this court, to have Ken Worthy brought in so we can have an evidentiary hearing before we go any further. Because how can a criminal prosecute or allege that I'm a criminal when they're committing all the crimes, Judge? Since I've been home, I've been making reports of police and other things, violations of law against me at the precinct. And no one listens to me. They just ignore me. But when people call and say, well, hey, Mr. McCreary did this, Mr. McCreary did that, they come, then it's found out nothing happened. You see what I'm saying? Like, they even borrowed me from the Secretary of State because I was in there trying to conduct business. Oh, well, we got a call that you threatened somebody. Oh, we found out you're free to go, but they just don't want you in here. That's not how this government works. Or the so-called democracy in which you guys call it, but it's supposed to be a Republican form. So.
Okay, people have to respond.
Thank you, Your Honor. We're here because Mr. McCreary, the defendant, is charged with 10 felony counts. I've heard a lot of law quoted today. Everything from contract to treaties, corporate, but the only type of law that matters today is criminal law. And under our state constitution, this court has jurisdiction. Article 4, Section 15, the circuit court shall have original jurisdiction in the matters not prohibited by law, appellate jurisdiction from all inferior courts and tribunals except for otherwise provided by law, prior to issue here and determine prerogative remedial writs, supervisory and general control over inferior courts and tribunals within their respective jurisdictions, therefore of the Supreme Court, and the jurisdiction of other cases and matters as provided by the Supreme Court. There's MCL section 767.1, several circuit courts of the state, the recorder's court, and any court of record having jurisdiction of criminal causes shall process and may exercise the same power and jurisdiction to hear, try, and determine prosecutions upon information for crimes, misdemeanors, and offenses, to issue writs and process and do all other acts therein as they possess and may exercise cases of prosecution upon indictment. And the Michigan Court rule, which are passed by the Supreme Court, Rule 6.008, Criminal Jurisdiction, Section A. The district court has jurisdiction over all misdemeanors and all felonies through the preliminary examination and until the entry of an order to bind the defendant over to the circuit court. These laws clearly state that this court has jurisdiction over these criminal matters. Furthermore, as far as discovery goes, I personally sent Mr. McCrary twice the discovery material. And I have the emails, copies of the emails to show it if that's necessary.
Dated, what are the dates?
Dates are not on here. May 24th, which was last week, and May 5th. So we sent in the discovery that we have twice now.
What email?
And
I'll just ask what email, because it's not here.
the second email, I paste and copied off the email that I received from with his documentation. Just here. So the people would ask that defendant's motion be denied and this matter is set for preliminary examination, where the people will have to show by probable cause that that a crime was permitted in the jurisdiction of this court in Detroit, state of Michigan, county of Wayne, and that crime under probable cause was committed by Mr. McCrary. Thank you.
Great, you have a chance.
Can I have a rebuttal? Okay, thank you, Your Honor. This gentleman, what's your name again, sir? Sawaki. Ms. Sawaki must be, in no disrespect to him or the court.
We're going to disrespect.
Well, no, I'm not. No, what I'm saying is, based on his analogy, he's very delusional because the supremacy clause overrides state constitution as well as state laws of Marbury versus Madison, 5 U.S. 137 since 1803. Secondly, in Shaney versus Winnebago Department of Social Services, the U.S. Supreme Court is clear in 489 U.S. 189, 1989, and the civil rights cases, 109 U.S. 3 says the court held the 13th and 14th Amendment did not empower Congress to outlaw racial discrimination by private individuals, as well as the Shaney. They don't have a duty to protect citizens under the 13th and 14th Amendment. Give me 1 second. Okay, give me a second. Okay, on page 10, the court held, the U.S. Supreme Court, under the Supremacy Clause, which is he is bound because, Judge, if you rule against me today, you must hold him in contempt of court and also hold him in treason. The court held the legislative authority of the Union must first make an act of crime, affix a punishment to it, and declare the court that shall have jurisdiction of the offense. Certain applying powers must necessarily result to our courts of justice. But jurisdiction of crimes against the state is not amongst those powers, Judge. See Hudson versus Goodwin. 7 U.S. 32 at 33 and 34, 1812. This is still good law, Judge. He's arguing a state statute or a state constitution. which the state received its power from Congress. So how can you buck the system which gave you power to act as a corporate organization? Michigan became a state in 1829, which Congress gave them their power. The U.S. Supreme Court clearly says that, like they say, people of the state of Michigan versus me. You're saying I committed a crime against the state. The Constitution just clearly says that from the U.S. Supreme Court justices in the unanimous decision in which this court, as well as the prosecution under Article 6, Section 3, the executive department has sworn to uphold, as well as the lawyer's oath in the Michigan Bar Journal. Amongst other things, they're committing felonies, and this court cannot conspire or enter into conspiracy with these individuals to violate my constitutional rights, Judge. And the law is clear. One more thing, if I may. My driver's license. And page 20.
You have one?
Pardon?
You have a driver's license?
Yes, ma'am. But let me, I'm about to go here. And agree that at the onset of these unlawful attacks by the corporations and its criminal agents, that he did reserve his rights under UCC 1-308, MCO 440-1308, UCC 1-103.6, siege offers driver's license. I reserve my rights on my driver's license, Judge, so the state knows this. I've never entered it because I was compelled to have a driver's license. And what I'm saying is they're committing treason.
First issue, can I see the email? I just want to make sure that
I give you my phone. I've never gotten anything. I have to show where I sent him the stuff, but I never got that back.
No, oh, let's say I just need to see.
No,
This is your email address.
it's Carnell, CARNELL, MCCRE@gmail.com, which I wrote it down for him.
CRE?
Pardon?
Can you spell the whole thing again?
It's Carnell McQuarrie, MCC. It's my first and last name @gmail.com.
CMCCR.
EARY.
Okay.
Also, there's a case I didn't bring with me today where concerning this type of document, he's trying to title this a motion, Judge, so it's a quasi contract which is recognized by the Michigan Supreme Court.
Between you two as what it is.
Pardon?
You think it's a quasi contract, he believes it to be a motion. That's
Well, I mean, it's
that's
clear.
the way it is. That's what it is.
Well, the federal law says that he cannot just see, and here the Supreme Court said that I'm the legislator of this contract.
Okay.
The litigation.
Yeah, your contract.
Yeah, this is in the Supreme Court. They have to obey the Supreme Court. Object.
What part?
I object, Your Honor.
There are some elements that people like to respond to.
Sure.
I haven't finished my
I just
oration.
want to discover. I
Haven't-
know, I'll give you, it's gonna take a couple seconds. One of those emails, the E is Michigan in there.
That's not my fault. They violate your order.
Mr. Kirk, can I-
Yes, ma'am.
Okay. Is the other one,
One of them has it spelled correctly, one of them does not.
so you should have received one of them,
Nothing.
Right.
and neither one of them came back as bad email.
Okay. All right, so Mr. McCurry, I don't know why you're not receiving discovery, you did not receive it.
He didn't send, can we subpoena Google and,
No,
litigate this and
This
show that
is
he
not,
hasn't
this
sent
is not a
anything?
trial, this is not an evidentiary hearing.
Well, can I say one more thing?
After we get done today, you confirm your email address, you can send a test email to make sure that he received it.
Well, he did. It showed me that he got my paperwork. He admitted in the last receipt that he received my
Okay,
paperwork.
and
So why would he send it? Well, why wouldn't I get it back? My email is legit. It's my phone right here.
okay,
Also a jurisdictional challenge.
before we get to that, Adrian or Cecily, you want to respond before we forget?
Yes, Your Honor, I do want to make a record. You know, this defendant has already availed himself to the jurisdiction of the courts of the state by admitting to having a driver's license. And also further add that the 10th Amendment has allotted and given complete powers to the states, which then allows the state to create criminal laws under which this defendant must avail himself to. I further add that, again, as the court has acknowledged, that this defendant has at least once received the discovery to his emails, to his correct email. So any more allegations of not receiving discovery would be improper, given that we have it at least proven that he has it at least once. And there have been no additions or corrections since the discovery was done the first time.
May I
Mr.
respond?
I'm gonna wrap this up, you can respond and.
Yeah, just briefly if I may.
Sure.
Well, this young lady here to basically
Mr. Sessions,
respond, Mr. Sessions, to respond to her statements in Michigan, they're locking people up for not having a driver's license. I was compelled.
there are people getting
But I
locked up
reserve
for
my rights. This was
murdering
the law.
people as well.
Pardon?
People getting locked up for murder as well.
Well, I understand that, but what I'm saying is the corpus delicti, they're going off written statements. You know the corpus delicti rule under the Michigan Supreme Court case, as well as the federal court case. Where's the body of a crime? They're saying ammunition, all this, that. Where's the guns at? Where's the victim at? Strangulation, where's all this? Where's the medical?
I wouldn't know because we haven't
And
had
then,
an exam.
okay, but no, jurisdiction, once it's challenged, it must be proven by the people. This is state and federal law, from the Michigan court. So I'm demanding that jurisdiction, I mean, they're already in default, but still again, I'm demanding jurisdiction be challenged, personal subject matter and territorial jurisdiction. Even when I was in prison, I had interactions with Kim Worthy, chief prosecuting officer for the state, and I reserved my rights then in prior proceedings, as well as I was compelled to obtain a driver's license. And I reserve my rights. That's all the law mandates, that I reserve my rights, which I have done. And right now, this lady, Mrs. Prosecutor, I can't remember her name, and Mrs. Sisson, Esquire Sisson, and this gentleman here, they're in conspiracy and violating federal and state law. They're committing crimes, and I demand that their oath of office, their law, their license to practice law, amongst other things, be given to me, as well as their bond, as well as you, Judge, Your Honor. Also, like I say, jurisdiction has been challenged, and they have to prove it first based on the case law, which I have noted in this paperwork. They can't get around that. We can say, well, yeah, they're talking about reserving rights and all that. Okay, but still the law from the state Supreme Court, Court of Appeals, and federal jurisdictions clearly mandates that once jurisdiction is challenged, the person asserting jurisdiction has to prove it. And all they have is statements. Under the corpus delicti rule, out of court statements is not evidence, so these charges should be dismissed. Where is the body of the crime, Judge? You went to law school, you're a practitioner.
I don't know because I haven't heard testimony to know.
Well, that's not how it works with jurisdictional
That's
challenges.
how, you know, that way. So, do you have any last?
Well, I would like,
Statements, because I'm getting ready.
okay, I would like to challenge jurisdiction again, which I have done from the onset of this case, personal, subject matter and territorial jurisdiction. State and federal case law is clear, in which this court being inferior to the higher courts must adhere to their oath of office, their bond, and so on and so forth, their license to practice law, and the Michigan rules of Code of Judicial Conduct, and must compel the people to prove jurisdiction, which they're asserting. Where's the proof? You have to show this court. That's at any stage of the proceeding, the law allows that.
Okay. So on discovery, I saw paperwork confirming the email address that you provided to the court is now the record, that discovery was sent. I'm not sure if it's an email, please don't interrupt. If there's another email you would like to be sent to, I will ask the prosecutor to do so. 2, for requesting license numbers from everyone. My name is right here in front of you. You can go right on State
I
Bar.
ain't saying nothing.
RP numbers are available for you to look up as they are for any general public. Okay. As far as venue, jurisdiction, and you mentioned this, you don't know whether I was appointed or elected, I was both. So I took an oath, uphold the Constitution of the United States, and the Constitution of this state to the best of my ability. And with that, I hear cases that were committed, crimes that were allegedly committed in the city of Detroit. That is the venue for this court. I know that you disagree, but I am letting you know that's what I have to follow based off of the oath that I took. And the right to have exams is under Michigan Court Rule 6.110 that governs preliminary exam, as well as MCL 6766.1 talks about your statutory right, not constitutional right, your statutory right to have an exam. And under, let's see here, where should I go next? I'm not going to continue citing the rule of law, but under MCL 600.8317, I have the power to hear preliminary examination matters. MCL 766.1 gives me the jurisdiction, and it states in Attorney General 129 Mich. App 128 specifically page 132, which is the 1983 case, and the district court has no authority to grant a motion for change of venue before a preliminary examination is held. The statute granting courts of record authority to change venue in criminal cases is only applicable to circuit courts in felony cases. We are at the district court level. We have not heard any testimony. I don't know anything about this case. So I am denying your request. I will call a motion regarding venue, as well as jurisdiction, or any allegations at this point that the people have been conspiring or conspiring to commit crimes. I would like to hear the testimony from the allegations, from the information and the complaint. So I would like to set this for an exam date so that we can move forward and actually hear testimony so I can make a decision as to whether or not the probable cause that the crime even existed. Mr. McCreary, I know you're not happy with my decision. You know the rights, you know your rights and what you can do. You do not agree, but we need to get an exam put on the calendar. And of course, you have a right to an attorney. You have exercised the right to not have one. But I'd like to set a date for an exam and move forward from there. Yes.
May I just place my objections? I mean, you made your ruling, but
And
may
I
I
said I
place,
know you objected.
yes, may I place my, no, I'm saying I have to do it verbally. I mean, for me reviewing past cases from the higher courts, it has to be in the lower court record. I would ask that this court allow an interlocutory appeal to the Michigan, to the Wayne County Third Circuit Court under MCR 7.101, 7.102, as well as I would like this case to be removed to the federal court under 28 USC 1441 through 1449, because this court, with all due respect, has committed treason against me and conspiracy with the state. Because under federal law, I had brought a federal question. Once a federal question is presented to this court must rule based on the federal question, which this court has clearly ignored. Okay, I mean, I'm just saying what the court, what the case law says.
You can't just come in here and raise a federal question and be able to shop and go to a different court.
Well, even the state says jurisdictional challenge.
Well,
I brought both case laws.
I understand that you're making a record, but until the exam is held, I can't change it based off of what happened.
Oh, no, I understand, but I'm saying you can make other decisions and rulings of law. May I ask this question?
Is it a question?
Is it okay for the court to ignore U.S. Supreme Court case law, which is in a superior court to this inferior court here, a district court? And I would, ask that this be removed to the federal court for adjudication, as well as Wayne County.
And I just said that until the exam is held, I can't change venue.
But I'm just saying the jurisdictional challenge, they're bound to respond, Judge. And the case law is clear, and this court is ignoring state and federal case law, which they're
supposed
supposed
to. I am ignoring anything. I sat here, I have a timer on my phone. I sat here and listened to you talk for 34 minutes and 54 seconds. So I don't think that I've ignored much of anything.
Well,
The average judge would not sit here and let you talk this long. There are time limits on motions and requests. So I think I've done a great job of not ignoring. I've heard everything you said. I've read your paperwork and I've addressed it and responded. I just don't agree with it. So I understand your objection. If you don't agree with anything that I've said, I understand that. And I am ready to set an exam date.
Well, I'm being compelled. May I have your bar number, Judge? Because it's not up there.
Look it up with my name.
I mean, I thought this was public information.
I gave you the freedom to go to the library, so you do it yourself.
And then also, I need their names. I don't know how to spell their names. I mean, can they write their names down for me? So I can file attorney grievance complaints with the Attorney Grievance Commission, Your Honor. I don't know their first and last names. I need this to petition the
I'd like
attorney.
to set an exam date.
I mean, I'm being compelled to go to an exam.
So we're gonna.
Violation of federal and state law.
For June. I'm thinking June 13th. I don't know if that works. Go first.
Yeah, that's my birthday. Y'all trying to bring me on my birthday.
Your Honor, I'm not in court that day.
Okay, let's not do that day.
Well,
But but I'm not gonna have to confirm.
Okay, I mean, I would like their names, that's all I need, so I can go
I
to
would
the
like
federal
them
courts,
exam
things of that name. I mean, I'm being compelled. Judge, you, right now, you have me here under threat, duress and coercion. I can't even work to support myself.
I allowed you to work.
Well, it's across the street, but that's not every day.
That's what you asked
And,
for.
and people have been
That's what you
contacting
asked
me.
for.
Okay, no, I understand, but people have been contacting me about a job. I've been in the community, I've been home.
You want to address bond? We can address
Sure.
bond after we get an exam date.
Well, I'm just gonna have a tether on. I'm not gonna run
I
out
don't
the
know
door and let them
what
get
you're
me.
going to do, but I want to set an exam date
I
first.
mean, I'm compelled. You, I mean, that's your call. Your call.
Okay, I need to set an exam date still, whether you feel compelled or not. June 15th.
I'm here that day, Your Honor.
Okay,
I'm here as a standby, Your Honor.
okay. Mr. McCreary, can you do 9:30?
I mean, I'll be here.
Yes.
Anytime you want me here, I'll be here. But I would also need, I mean, they're saying about the email, why can't they just print it off like they used to back in the day? It's a violation of MCR 6.201, like when I asked for their bond numbers and other things.
You just asked.
That's pertinent. I did, and they
Just
told me they
ask.
weren't gonna do
Your
it the
Honor,
last time we were here.
Mr. McCurry, let the record reflect that I have 15 pages of discovery that I can now hand to the defendant. This is all that we have.
Is it complete? Because I would like an in-camera review of your file as well, on the
It
MCR
is.
6.201. Can I review his file on the MCR 6.201? So, because they have a history of holding stuff back from me, which is all,
That's a strong
document.
allegation for people you don't even know.
what I'm saying, her office, Kim Worthy's office, they work in behalf, they're her subordinates. Notice the agent is notice the principal, notice the principal is notice the agent.
I'll
Under
put
state
on
and
the
federal
record
law.
first that Mr. Sawaki has handed over 15 pages of a hard copy of discovery.
Is there medical reports in here as well? Because he said someone was shot and beat up and, where's the ammunition? I need pictures of the guns and all the stuff. These fictitious guns and everything that they're talking about they have.
You think that they're going to hand you the guns?
No. What I'm saying is they say ammunition, guns, and other charges. Where's the evidence?
That's
This
what
is
the
just
exam is for.
allegations in violation of Opera versus United States. Like, even if I went into a precinct and confessed,
Okay, let me get the date, June 15th at 9:30. Legal discovery has been provided, any additional discovery?
No, Your Honor, there is no discovery.
I would request additional discovery.
There is
if I
no
may.
digital discovery to turn over the people
Oh,
who
digital.
can have it.
Oh, I thought it said additional. Well, can I request additional discovery because I would like to say this if I may. Kim Worthy, I believe it was
You
last
don't have
year.
to say, you can just ask for a discovery order
Okay.
signed.
Well, yes, but I would like to tell you why.
I
I mean,
would
for this court
object,
to
Your
rule.
Honor. I'm going to object to the defense bringing up any issues of Kim Worthy and past experiences.
She's
With
the
this court,
prosecutor.
Your Honor, I am asking the ability to speak uninterrupted from this defense. This defendant has now on more than one occasion raised issues of past cases. Those cases are not relevant to this hearing. The people ask that this court prevent the defendant from raising any issues of past hearings or past experiences with this office so that we can focus on this hearing alone. The people have turned over all the evidence that is available to the defendant. Have not turned over, we have turned over everything in our possession that we can to the defendant. If the defendant wishes to seek any other items or specificity, he would have to place that in writing.
Well, if I may respond, there's case law from the Michigan Court of Appeals that rebuts what you say. It's for purposes of impeachment. I've done it in many other cases, People versus Stataway, to test the credibility. And this is
The
law.
prosecutor and I both just said that you want to request anything else that we don't know if it exists, put it in writing.
Right. Well, my thing is,
Oh,
Mr.
I need you to
McCurry.
acknowledge that.
Oh, I mean, I hear you. And I respect what she's saying, but she's totally wrong. How can you buck the Michigan Court of
So
Appeals?
what do you want? You just
Well,
asked for
I was
discovery.
trying to say before
So-
she cut me off, that Kim Worthy issued a list saying that officers who have testified in the past and
Sure, that's a-
falsely in court cannot testify in the future. My brother has committed perjury in Chief Judge Burke's courtroom.
Okay, these are
in
all
Wayne
things
County.
that
And I would
will
like
come
to,
out.
and I had the evidence here, I would like to admit it in evidence.
Those are all things that you can bring up during the exam. If he gets to take the stand, you can address all of that, okay?
Well, I'm entitled to an evidentiary hearing to admit evidence.
It's gonna be called the preliminary examination. Evidence is gonna be provided and presented. Yeah, we can play when it shows up, okay?
Well, I hope he does, because it's not gonna look good for him. And they refuse to prosecute him for crimes against me.
My question is, do you still want to move forward, representing yourself on the exam?
Ah, definitely, yeah.
Okay. I just wanna make sure.
I'm entitled to that under the First Amendment to the U.S. Constitution,
I know
Article
what
1,
you're
Section
entitled to.
13
I
of the
just asked
Michigan
you
Constitution.
procedurally so that we can be prepared for the 14th, hour on or 15th, whether you want an attorney or not. That's all. So if you do, Mr. Washington needs to prepare. If not, then we're gonna continue our how we have it.
Well, I request that all prosecution witnesses be put on the stand per the court rule, as
No,
well as
you
the
can
defense
call
witnesses.
them to the stand. You have a right to call witnesses. So if you want them on the stand, you have to call them as your witness.
I would like to call Kim Worthy. How do I go about doing this? Getting your subpoena power, your assistant of subpoena power to bring her into court? Because the case law is clear from the Michigan Court of Appeals that I can bring in evidence in prior cases where the prosecution has committed criminal and constitutional violations.
Trace, I'm not bringing Kim Worthy on the stand unless you was a witness.
I'm saying she's the chief officer.
If she's not a witness in this case, I'm not calling her to the stand.
Well,
wouldn't be me
can I
calling
call
her
her? I
with
can
me.
call her as a witness, which you just said.
Subpoena her.
Okay, so can the court assist me with that? In the subpoena?
That's what you have Mr. Washington for. I'm not involved in helping you with your case. That's not my
Well,
job.
sua sponte, the law says sua sponte, you
nothing.
can.
I'm not helping you with your case.
I mean, I'm not trying to get you, I'm saying so far as the issuing the order for subpoena to bring her in as well as other witnesses. I have other
Mr.
witnesses. that are
Washington
like-
is a very trained and knowledgeable attorney. He can tell you what you do if you like to. All right, anything from either party? Else?
Can you give me your name, sir? And both you guys' names, so I may,
File a grievance.
I mean,
Who's
I
gonna
have a
willingly
right.
say, here's my name, so you can file a grievance?
I mean,
and
that's
put a
the
lien on my
law.
house?
This is the law. The
Your
law,
Honor.
according to Michigan Supreme
Your
Court.
Honor, just so that the record is clear, both Mr. Salviki and I placed our names and key numbers on the record at the start of this case. Our names are
I don't know how
also
to
in,
spell your name.
our names are also in emails that were sent with the discovery to the defendant.
So we're gonna go off the record. We're done with this for today.